Okay, we're back. This is Sean Ward again, Fashion Brand Launch. We're going through all of the different sales forms that we need in order to grow our business. Let's continue on with the international distribution contract. So again, we talked about going international. You nowadays, even if you are an e-commerce based company, it's going to be very, very tough for you to actually get into brick and mortar stores in a significant way without having some sort of partner on the ground. And obviously, you'll need someone that knows the local currency, who knows actually all the retail shops, the boutiques, department stores that you want to sell into, who can speak the language, who knows the currency, and just the overall lay of the land. It's very important that you partner with someone who knows the territory and then also can grow your business without you putting much effort into it. So let's dive into the international distribution contract and show you what it should, some of the major points of what it should actually include. So here's just a table of contents for it. Again, as I mentioned before, if you guys want to have a copy, kind of a template to work from, I can email this to you. Just contact me on the platform that you'll be using. So first, we'll have the background information, definitions, just kind of outline what means what when you go through this. The distributorship, which outlines basically what the agreement is going to be, was going to consist of, the terms of the distributorship, the orders and price, obviously the limits and minimums that have to be acquired in order to continue to do business with them, support of sales, acknowledgement and protection of the proprietary rights. Again, making sure that even though they're representing you, they actually do not own the intellectual property of the company. Just some additional covenants, things that also are going to be covered. Your limited warranty and service obligations, the termination clause, just in case something needs to be terminated or you want to get rid of them or they want to get rid of you. It has to be with cause. Some of the general outlines and then representation and warranties. A lot of this stuff is legal mumbo jumbo, but it's important to have. And then last but not least, the signatures to make it official. So distributor agreement, basically this is just outlining the day of the agreement, who it entails, the company, where you're located. Here you see Detney Footwear Incorporated, New York, USA, at the address above and this is a New Zealand company that we were going a distribution agreement with. You want to make sure you have the correct country there. Some background information, basically saying that the supplier currently manufactures and markets products, et cetera, et cetera. Definitions. Affiliate means that person that directly or indirectly through some intermediate controls the common control or such person. So someone who represents the company. Products shall be men's footwear, clothing and accessories, net purchases or FOB, territory and the country of, underlined, the trademarks, and then trade rights. So you basically just make sure that, again, this is just legal, basically necessities that are going to be in the contract where you actually just have to define what you're talking about. So later on, they know who you're talking about and what you're talking about when you go into saying products and trademarks. Section 3 is distributorship, the appointment of the distributor. It talks about the territory and where they will have basically exclusive rights to it, and then nature of the relationship. The sole relationship between the supplier and distributor under this agreement is that the vendor of the purchaser, respectively, in this agreement does not imply or create other relationship. So basically, no one's taking ownership of this. It's basically a distribution agreement only. Let's see, going into 3.3, limitations of supplier distributors' rights. Look, you see in Part B, that's really important. For so long as distributor meets the annual purchase requirements of products, supplier will not directly or indirectly wholesale the products to dealers in that territory. So as long as the distributor maintains the minimum requirements as far as sales, then the brand is not going to go out in that country and start to do sales on its own. Let's see. E is important. Distributor will not purchase the product from any party other than supplier and its affiliates. So even though the distributor has the rights to that country, they can't just go behind you and go try to get a better price at a factory to make your product for them. Continuing on to section 4, the terms, basically talking about it will commence on, so the start date of the agreement. So maybe it's actually, as you actually agree on the terms, you would just put the dates in there. Again, this is your form that you're going to send to the distributor. The distributor may have their own contract, but you want to make sure you send them a contract that's very heavily favored towards what your liabilities should be. So this would be your agreement that you send to them. And then that the agreement will terminate on, so say for instance, it's going to be a 1-year contract or a 2-year contract, unless terminated sooner pursuant to Article 10, which is later on. And then blah, 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 and if such notice is given, automatically will lapse on, et cetera, et cetera. So just basically talking about when this contract is valid and when the contract ends. Number 5, orders and price. So again, this is probably the most important section, because to have a healthy relationship with a distribution company, you want to make sure that they are selling the product. They're not just sitting on this exclusive agreement that they actually deliver, because if they don't, you want to move on to a different distributor to represent you. So look, 5.1, sales goals. And as you can see here, we outlined this a long time ago, and basically for the first year, we wanted to make sure that they did annual FOB purchases of $75,000. That's FOB is freight on board. We talked about that in the previous course, but basically that is not the retail price. That is the actual price that they're paying you as the brand owner. So they at least have to purchase $75,000 worth of goods from you their first year. The second year, you can see we a little bit more than doubled that, because if you see in the first year, we started in February, so we lost a month. So we mandated that $165,500 be purchased minimum in the second year, and the third year, $275,000. So basically, that's their minimum purchase every year. If they do not meet those, then they can almost violate this agreement. So you see in 5.2, you see it says it is expressly agreed that if the distributor fails to order said minimum amounts of products during any of the above contract years, then the supplier, which is your brand, should have the right to terminate the agreement or to change its appointed to a distributor hereupon from an exclusive one to a non-exclusive one upon written notice to the distributor to such effect. So basically, if they do not meet these minimums, we can go and have someone else continue to sell in addition to them. The purchase orders should be done in writing. That's 5.2. 5.3, marketing information. They agree to make itself familiar with the trends and preferences of the customer. 5.4, the price of the products between supplier and distributor shall be advised by the supplier to distributor. So basically, you as the brand will let them know what the suggested pricing should be for wholesale and suggested retail. And then sales samples are basically going to be purchased by the distributor. Going into section 6, support of sales. This basically just says that at all times throughout the term of the agreement, a distributor will perform all of its promotional obligations. So basically, they must also market the brand by supporting it through marketing initiatives. Okay, so they have to use all of their efforts to do a reasonable amount of high quality marketing in order to help them succeed. And then 6.2 is right to use names. So basically, the brand, you are basically given the right for them to solely use the trademark and trade rights, but only in connection to the promotion of the products, nothing else. Continuing on, you can see in section C, distributors shall not register or maintain any domain name that includes the trademark. So, say for instance, a distributor is in Berlin and they want to go out and trademark your brand's name in Germany, they cannot do that. Okay, even if the trademark doesn't exist, this basically is keeping them from trying to create some sort of rights beyond this agreement to actually distribute your product. Advertising, this is key. If you can follow my cursor, you will see here that the distributor shall spend a minimum of 5% of the distributor's net wholesale sales for advertising and promotion of the products. So basically, their sales are going to be wholesale sales, right? Because they're selling to retailers. They have to, so say for instance, the first year they do $100,000 in wholesale sales. They must basically put $5,000 towards their advertising, okay? 5%. That's basically making sure that they continue to advertise the brand and give it a chance to succeed. 7 is the acknowledgement and protection of proprietary rights. So basically, they're just saying that anything that belongs to the distributor is the property of the distributor, and anything that is property of the brand belongs to the brand. Additional covenants, taxes, compliance with ordinances, basically just for them to make sure that they take care of their own taxes and obligations with the government, and they can't go basically bootleg with your product. Limited warranties and service obligations. Again, this is more, legal stuff, but basically you'll see that any defective products shall not exceed 2%. The warranty of the supplier set forth in subsection is the sole exclusive, therefore no other warranty is expressed and implied. Again, legal. Claims and claims periods. Termination. This is important because you want to make sure that how this contract can be terminated, and obviously if you see all these different bullets, it must be with some sort of cause. So you can see just in section 10.1a, events of the termination, this agreement may be terminated if the following events happen. Distributor fails to perform one or more of the obligations of the agreement. They fail to comply with any application, export, license, or control. In event of change of control of distributor, the party shall terminate the agreement. So say, for instance, the distributor sells the company to a larger company. That could be an event where the brand can terminate the contract if they don't want to work with that, the new owner of that company. And some other different types of variations on when that contract can be eliminated, terminated. Even more termination than general notices. Everything shall be done in writing. You can't just call someone and leave a voicemail to have a notice. Different waivers, assignments, basically saying that 11.3 says the distributor may not assign any right or interest hereunder or delegate any obligation hereunder without the prior written consent of the supplier. So they can't assign the distribution agreement to another company. Continuing on, binding nature. This agreement is binding upon insurers to the benefit of parties hereunto that extent assignable their representative successors and permanent assigned. So again, more legal stuff. You should definitely have your lawyer look over any contract that you have, and this will be one of them. A lot of this will be just different forms of language that makes your liabilities reduce through the process. Representations and warranties. Again, more legal, mumbo jumbo. And then finally, the signatures. So again, this is a standard distribution agreement. You can see this is basically 11 pages. If you want a copy of it, let me know. I'll send it to you. You'll be able to work from it. Again, make sure you have legal counsel review everything to make sure that what you're doing protects your company. And with that being said, thank you so much for joining. You can see us at WardandFifth.com, at WardandFifth in social media, and I will be back with the last lecture of this course. Thank you very much.